Good afternoon, ladies and gentlemen. So you see library campus around, and we now turn to review the topic about a statute authority of agencies. So we would get the middle of a class progress, and one other class you will be required to make presence. Class presence is required on Thursday, and I personally capture the lecture. I videotaped it, so I now consider if it would be available for your review. I'll later contact the technical support, since the last attempt actually fails. The file size would exceed the limit. So what is the videotaped file would differ and requires a much capacities of in terms of a personal computer. In terms of a personal computer. And I have reserved many cases, undealt actually, left for further review, I promised. And 3 illustrations. Then there will be our work that could be supplemented in makeup class. In this class, we will consider the next topic, which is leveled with the equal coordinate branches in tripartite scheme of government. So previously, we overview the constitutional authority and the way 3 branches are assigned, the governmental powers. The draftsman would rather very shrewd and prepared to shape any wisdom in constitutional state paradigm. So bicameralism, separation of powers principle, and the kind of a constitutional sovereignty you see over many other political powers or influences of nation. So and actually, its concept could be shared in one focus concerning a delegation doctrine. What is that a principle could operate for? And so Federal Sentencing Commission and others would be a good illustration you could encounter about the points of contention and key laws deliberated by the judiciary. And actually, the Congress is very central in creating a public policy, and their power is what actually creative and law generating a authority, since it could begin from the bottom line of the problems, contentions, or issues of a society. That context could be posed, however, in stringent oversight by a non-delegation doctrine and separation of powers principle. So that could not be arbitrary if they moderate the constitutional powers in any a collaborative or coordinative manner. So what does it mean? Intelligible principle, you see. So the judicial control also intervenes, and check and balance scheme could be well starker, you consider lastly. And in this class, you also be introduced to one important case titled a charter. So the case involves also some delegation and oversight of Congress to preserve its accountability, which is political. There are many reasons that the legislative branch could delegate the powers. For example, they would not be subject to any public criticism if they intervene in any complicated and sensitive public matters contended by competing interest groups. So there could be one reason that the legislative could like to avoid. So one way to delegate the issues and powers within the hands of a bureaucrat. And of course, the expertise and time could be element. So the administrative agencies are often be staffed with some experts in their specific field, and a technical matters to be decided and considered would increase as the nation and war would transform. And what we now see such a high extent of a new paradigm, or the informative society, web-based industry, and online context of deals and interchange in terms of culture and intelligence would flourish. So you also consider later in the class difficult questions about occupational safety and health, and what is that? Environmental protection, for example. What is Cleaning Act? You see the case titled Chevron, which is viewed one of most important authority about administrative law, and definitely most cited cases conform through the Westlaw others. So actually, the evolution into any computerized system of a public knowledge and governmental capabilities could well begin with the Westlaw, for example. You will also consider the website titled Federal Register. It provides a daily context of a massive public notice and a comment as required by law to see a routine notice board to interact with public. So they stack the massive information and could provide some rules and their commands, and also space for interaction could be available. So what intelligent government is also now will be embraced, and which is a factor leading to many dissidencies and also disagreements by the judiciary. You see in later cases, for example, in some case the judiciary defers to the discretion of a administrative agencies. However, in some case, they could invalidate the rules or deny the implementation of its law and public policy based on normative concept. We considered in last class the normative limits of a delegation doctrine. The concept could penetrate, among various elements, law, science, and one concept framed in normative way would substantial evidence you consider in later case concerning admissible law. And therefore, you will begin with the law of separation of powers, which is constitutional, but could be understood in any stern sense, you see. So we now are very well versed with separation of powers. Most high school graduates know that the U.S. Constitution separates the government into three branches: legislative, executive, and judicial. That is one basis you will look into the normative dealings among three branches. However, more perplexing and complicated would it be that absence of clear statutory authorization or even political approval. So the public statute would not be comprehensive and exhaustive in many capabilities. So the subject matter could be limited since it involves higher cost about a public transaction and others. However, some imperative or extreme desirabilities may be presented by a scientific group and experts. So Food and Drug Administration may be affected by new discoveries and scientific findings. And public health and general standard of a workplace safety should be ensured in any way, since the role of government is actually the sacred commission, elegantly pronounced in the preamble of the United States Constitution, promotion of general welfare. What is that? It could be wider in a sense. Typically, we consider the economic and environmental and public issues could come front. So we have many pertinent department units to respond with the question. For example, EPA and OSHA. What is the organization or act? Occupational Safety and Health Act, and the kind of notable public statute was subject to public criticism more intensely than any other ones. For example, environmental group may show high tendency to challenge the propriety or permissibility of the statute. It could not resolve the cause perfectly and may raise some grievances and complaints. So I captured one picture for your sensibility. What is this? This in pictures the concerned people about environmental issue. How do we shape the environmental policy? It's actually a serious issue to affect generations and generations. The context of it, what it just not the problem of ours, and the environment could be succeeded, and it will be a national assess, a common assess, notwithstanding a specific generation. So from Korean context, the standard, how do you consider the standard? It could be affordable or in some cases sufficient. There are many competing interests about this issue. The environmental regulation could increase the cost of a industry. So costly change would not be friendly with the enterprise. How do you place your position in terms of ideology? You consider business friendly or environment friendly, or industrialist, environmentalist. So, and the above picture shows what the patrol of a police, national police, in the end to detect a drunken driving. You can see, and should be a nighttime, and some of national, some of police officers stops and collect any evidence. The evidence collected by a police officer in this way was once challenged in courtroom. So, actually, now the society is science-based, and the device used to collect evidence could not be precise about lapse of time and others. Interesting. And I illustrate this picture to support your understanding about administrative fines. It is one of process that the driver's license may be revoked, or in other case, some small amount of fines could be imposed. In any case, the issue of compliance in terms of administrative enforcement is very important, and that is a critical area that the law and public policy could make a focus. There are many ways and could be classed into two basic ambit of instrumentality. Sanction would be one way to respond with a statutory requirement and a higher extent of compliance. And the other would rather be technical, so we call administrative techniques to ensure compliance of statute and rules or public policy. consent settlement or industry guides. In some cases, cease and desist order or other corrective measures would be used. You see, for example, the false information put to the public in the way of a public ads and others could mislead the consumer, and which would abridge the public interest seriously. So, Federal Trade Commission or Federal Communication Commission could use the cease and desist order, and in some cases they compel the businesses, enterprises to correct their previous statement in others. So the falsification or misleading context of ads could be redressed. So that would one way to ensure compliance. So the administrative tools could vary and depend on the context, for example, players, who is the actors, and also what is the nature of norm, and how is the enforcer. So am I confident on the scope of implementation, or the rule is mandatory, or gives a scope of leniency about ways of response and extent of penalties, or compulsion, extent of compulsion. So actually that involves a scope of factors to be contemplated beforehand about enforcement. So there would certainly be some most adequate way to enforce. In some policy area, the cease and desist order will effect at the most. However, in other cases, we see the economic sanction or even criminal sanction are required. So we often see one of a serious tools, and which is severe, and actually, and it could operate as retributive and preventive. So it could serve as well, like the cease and desist order or other. And one other interesting device the federal government often exploit to forge their federal goals, purposes, would be cutting the funds or other available financial assistance. Actually, you consider a limited context of a federal power, which is, however, supreme, from the Federal Supremacy Clause. So their principal way would not to regulate in structure and a basic framework. That could not be seen as original, since practically the federal power will go to be in same extent with the unitary form of government. In understanding theoretical basics, it should be. So their device could be provisional. So granting of federal funds would a very effective way and most feasible way without any violation of Constitution. So they encourage the state government or actors or within the target of a specific policy by granting funds. You can see the research funds for public universities and research institutes. Of course, the public universities in South Korea are heavily dependent on governmental aid in financial terms. That could well be outrivaled when we consider the American dynamism in public interaction of a public actor. So they like to impose, for example, public health standard or the manner to use the interstate highway by providing funds. If the state who is unfriendly with that federal deals, then could be practically discriminated, actually punished by the reserve of the funds. The cutting of funds would be any most effective way when the interaction could be framed in that so the state agencies are actually termed as a fourth branch in the framework of United States government. So they would not appear in the Constitution itself. There are no oppressive chapters about the state agencies. Of course, some selective public office, which is major and affect significantly the policy of United States, could be illustrated on some paragraph, and you that would surely be your experience when you read through the Constitution of the United States. There is no formal chapter about that. We have 3 chapters basically: Article 1, Article 2nd, and Article 3rd, each occupied by 3 branches of government. Then you have the rest of 4 articles, which deals with very classic context of a controversy and structure in terms of a democratic government. You consider search and seizure, and actually also you will see the context of the state privilege of U.S. citizens, since it adopts a federal system of a nation. That will be all, and we call it one of most important classic document in terms of a constitutional culture. So what is Constitution? It is basic law to structure the government. That is most important theme the Constitution has to respond with. What is next? We have a Bill of Rights, inviolable or inalienable concept of human rights that could be conformed in the preamble and followed by the main articles, followed by amendments behind the main articles, 3 articles. How is that seen in the Korean Constitution? The order would be promoted. You see, we have Bill of Rights in any urgent priority. So the freedom of political party, right to privacy, right to decent habitation, what is. So a scope of human rights were placed in order. So we have very classic constitution. You will see later in case such important comment by Justice. What is that? In Chora case, he mystically sealed over the structure of government. What is that? What does it mean? He mystically sealed. We use the word often in the physics. What is airtightened, or so very ordained and inviolable. You see, so which was used to denote the separation of powers principle. So it is very inherent and stringent to bar any action. The check and balance could come later, as you consider in concept. So the first point would be separation, absolute separation among three branches. And how do we connote and identify those powers functionally? So we could derive the essences of power in terms of function and origins and attributes. So we return to the fourth branch viewpoint. You can see the Korean people could be illustrated for your understanding. So we now have a special committee about constitutional reform in the National Congress, in National Assembly, and they now diminish the power of president and split it into two units in dimension, what administrative branches led by Prime Minister, and the sum of emergency powers for the president, and crucial sphere of a national agenda or issues could be resolved by the office of president. A normal function of executive government could be undertaken by other authority. So we could have four concepts in terms of the governmental power and structure, which would be submissive to independent authority as spelled out by the Constitution. So that could be formalistic and could well resemble the dynamism of U.S. Constitution in practice. However, there would be no chapters or places for state agencies, administrative agencies in the United States. That would not be the case in the possibly expected a constitution, which would be reformed. I'm not sure. The late president would not favor the constitutional reform, as we have heard of. So the constitutional dimension could be foundational, and the statutory dimension about authority of agencies also would be highly profiled, and in many senses would practically more important. You will see the very similar context of deals in the United States judicial preserve over the cases dealt. A very good way to resemble our practice. You may consider the attitudes and styles, judicial styles of Korean authority, for example. What is the statute of provision, and how do we connote these terms, or what is the restrictive intent actually, which should be enforced in this courtroom, and how is the legislative history gone, which should be viewed as pertinent to resolve this case, so affect the understanding of a specific provision, and which is actually a complementary with the expressed or implied language of a statute. So the structure and judicial style could converge, which is distinctive from the private laws. So you will see another attitude which begins with a long story involving the facts and also the precedents to be analyzed, and the ways to be to utilize the inductive reasoning. So comparison and analytical reasoning or could be undertaken to arrive at the terms of proper law, which is governing to resolve the case. And in some cases, they have to go, in some sense, desolate waters in a new area, which the specific judge should endeavor to devise his own rule. Then it could be another precedent to be distinguished by the subsequent courts. So the ways of interaction in private law involving common law tradition could be made very distinct, you consider. However, in the public law, often involving the statutory interpretation, could come to be a peer in attitude and judicial style with a civil law traditions. Nonetheless, the important question is how to shape the scope of discretion. For example, you will consider later in Chevron, one leading case, as I've introduced, could apply a two-steps analysis. So the statute would not be crystal clear at all. Often they use vague and ambiguous terms, and that concept could also be concerned in terms of a APA, or Administrative Procedure Act. It is an important act, and it has guided two ways of involvement of administrative agencies: rule-making dimension, which would be critical and make a serious impact on public lives of the United States. And one other dimension is a discretion of administrative agencies, which would be coupled with a rule-making. Then what is the last concept to be imparted by the Act? It is interpretive authority, which could be delegated to the administrative agents. So it chapters and sections, which is very insightful and must be a general authority to affect the role and responsibilities of public agencies. It is the official name of this act is the Federal Administrative Procedure Act. We often call it abbreviation APA, and passed by the United States Congress in 1946. The last indication would be called as public statute, 5 U.S.C. 551. This law codified a lot of common law that had developed, particularly after the Great Depression in 1959. So it is one point to be distinguished. You see, actually, the common law tradition could share this tendency even in the preserve of public law. So at first glance, the role of court would be pioneering. So the contention and disagreement could be raised in courtroom, and the case laws would be compiled, which could be developed into any statute. Before that time, the government was facile about how businesses and corporations did business. So basic point to be confirmed about the previous discussion. President Roosevelt elected in 1932 a number of agencies created to help deal with some of the excesses of business dealings. State of Wisconsin Administrative Procedure Act, Chapter 227. So I have accepted from the website, and the similar kind of a state act would be adopted. So you also consider the importance of a judicial intervention and judicial control, as you see, for example, in Dole case. That would come in contrast with Chevron principle. So actually, when we get down to the statutory authority of agencies, we will confront some more practically perplexing questions and others. First, is there any clear statutory authorization? Some important urgency or emergency of public needs may impel the state administrative agencies to implement some public policy orders without a clear statutory authorization. And that could not be affronted first instance, since there are a scope of undetermined matters which is submissive to the authoritative agencies. However, that could be captured in any oversight context. For example, the interest group and public pressure could intervene to subject the agency's action to question. Is it permissible or grounded under the Constitution and other pertinent statutes? That could be transferred to the judicial review, for example, in development of struggle waters. So, in some cases, even political approval could lack. But the public agencies could act or create a policy to address the public needs. If the Congress could act, the problem could be diminished. However, still problematic, since the statute language is abstract. In some anomalies, vague or ambiguous to confuse the interpreters or enforcers. So that context could be dealt in some of cases you will see in the projection. What is first case? It is a very leading case in the constitutional and administrative area of law, or charter case, Immigration and Naturalization Service. In this case, charter, who is a foreigner, and decided to be deported. And the Attorney General decision on charter's deportation would be deemed general and pertains to the kind of legislative function, according to the court viewpoint. Then, what would be wrong in this case? In the court view, the Attorney General decision would be based on the statute, where the Congress would delegate some power to the Attorney General, and later reserve the power to oversee that decision, whether it is right or proper or permissible. So the statute actually is intended to ensure oversight and accountability of administrative agencies to the parent agency, what we call a Congress. That would also can be solved in terms of a two school. You will see later what is bureau dominant theory and a principal agent theory. What is principal in this case? How do you consider Congress, President, and Supreme Court of the United States would be principal? It would be 4 branches without any constitutional chapters. So the administrative agencies are accountable to the kind of a constitutional institution. So they would exercise some power to oversee the administrative agencies. So legislative veto is to ensure political accountability of administrative agencies. However, it was struck down actually in this case since it violates the structure and terms of a constitution. So, according to the court opinion, the Attorney General decision is legislative function. And we see the authorizing statute underwent the bicameral passage. So it is a statute enacted by Congress, and according to the constitutional requirement, was presented to the review of President. So a presentation clause will require that the bills resolved in the bicameral Congress should be signed by the President. The President is actually a principal officer who is responsible to execute the laws. So he should be signed, which is a constitutional mandate. Could not be observed in any normal context of arrangement. So the statute could not be standing and must be revised if Attorney General decision could be reviewed in any constitutional way. Since Attorney General decision is legislative in view of a court perception and understanding. And the court also pointed out the bicameralism actually highly implicating in this case. So when we see the deals of a U.S. Constitution, the Constitution specifically provide a provision or clauses if one house may act alone with the reviewable force of law, not subject to the President's veto. What is that? In our expectations, for example, the House of Representatives alone was given the power to initiate impeachments. The Senate alone was given the power to conduct a trials following impeachment on charges initiated by the House and to convict the following trial. So the Senate alone was given unreviewable power to approve or to disapprove presidential appointment. Fourth, the Senate alone was given unreviewable power to ratify treaties negotiated by the President. Except for these four cases, all the action of Congress could be taken in a collaboration and a joint resolution by of both houses, Senate and House, in terms could consummate in Congress. We call Congress. However, in this statute, Attorney General decision could be revoked with the review of one house. What is that gone wrong? So, all the congressional action could operate in jointly. That could that structure could be encroached upon. So bicameralism is one basis that the code see the action as evil against the Constitution. It contravenes actually the intent of a draftsman and others. So actually the separation of powers principle is fairly insistent through the bicameral context of congressional arrangement and tripartite scheme among three branches of government. And also we see the implication which arises from the presentation clause and president veto. And in the court term, you see, for example, examination of the action taken here by one house, pursuant to 244C2, reveals that it was essentially legislative in purpose and effect. In purporting to exercise power defined in Article 1A, Clause 4, to establish an uniform rule of naturalization, the House took action that had a purpose and effect of altering the legal rights, duties, and relations of persons, including the Attorney General, executive branch officials, and charter, or outside the legislative branch. So it is a uniform rule of naturalization and pivotally intertwined with a crucial preserve of a private interest, the rights and duties. So actually, the item would well be conceived as legislative and was only submissive to a statute generating institution, creative in the essence of governmental powers. And the legislative character of the one-house veto in these cases is confirmed by the character of congressional action in the plans. Neither the House of Representatives nor the Senate contends that absent the veto provision, in 244 or C2, either of them or both of them acting together could effectively require the Attorney General to deport an alien once the Attorney General, in the exercise of legislative authority, had determined the alien should remain in the United States. So how much do you agree with the court viewpoint? This case actually has altered the basic concept about the congressional power. Actually, we see it enjoys a scope of a power since it is creative and actually originating in terms of public policy and their innovation. For this case, the Congress would revamp the ways of deal among the branches. So the Congressional Review Act in 1995 was enacted to respond with this judicial theory. So now the legislative veto could be practiced in other in other ways. So on the basis of a congressionally harmonizing way. So the president could also be another player to be dealt in this statute. So the joint resolution would be mandatory if the rest of the decision, the decision of administrative agencies would require the congressional review. So then we see no contradiction with this judicial terms. So joint session could guarantee against the argument of bicameralism, and also the president could respond in terms of statutory mandate to collaborate. So now the contemporary practice involving a illicit veto would approach in two folds. You see, in one case, the decision or action of administrative branch agencies will seek approval of Congress. It should obtain approval of Congress in order to legitimate their action or decision. The inversion would be true in the statutory scheme. So you, in some cases, disapproval would be sought by the administrative agencies to endorse, to obtain, to endorse their action. We'll consider another issue in next class, or some review about a basic viewpoint in terms of public policy. We consider bureau dominant school and principal agent school, and we'll have investigate some of summary for your knowledge about accountability of administrative agencies and administrative enforcement. And we hopefully wish to complete all the cases. However, would not be exhaustive, I expect. Okay, thank you for your attention, and after a short break, we'll meet again.